Realisation that relationship breakdown is imminent is often a stressful and upsetting affair. Clients can rest assured that many of the solicitors at Martin Tolhurst are resolution members and committed to resolving disputes in an objective and non-confrontational way. I see both men and women in a fairly equal split of clients. They range from relationship breakdown from the cohabitation sense to divorce clients that are coming through to our firm, and also children, residence and contact disputes. Those sort of people are looking for initial advice most of the time that they can then take away and discuss with their partner, with their spouse, and then look at whether they need any further legal advice. What we attempt to do is a form of one-stop shop at the start to give the ground rules and the basic divorce and separation principles and what they need to be thinking about immediately. And then after that, specifics can be given to them as to where they need to go and where they need to focus their attention. You don't necessarily need legal representation from the outset. Most people believe that when their spouses have taken legal advice or that have solicitors on board, that they're somehow going to be disadvantaged or prejudiced. What people need to understand is that they can gain that reassurance that they're doing something correct right from the outset, and there's a sound basis from which they can start their case effectively. Other people need that reassurance that the legal costs are not going to be that expensive. Solicitors often are able to give fixed fees right from the outset. The way the process starts is that you need to decide whether there's going to be an imminent separation or not, and then if there's any jointly owned property as to whether that's going to be sold or whether there can be any purchase of the property by the other party to effectively buy out your claims. At the outset, there also needs to be a decision as to whether you're going to divorce immediately or whether there's going to be an element of separation and then divorce later. You need to take specific advice as to whether that might prejudice your rights in respect of financial matters being dealt with and whether you can gain a binding agreement right from the outset. But divorce can be started at the start or effectively at the end, with matters being dealt with and any paperwork drawn up throughout that process. Divorce can sometimes raise acrimony between parties, and if you're looking at effectively separating first and then dealing with financial matters at that stage, it can be easier to deal with financial matters and resolve them before the divorce and the acrimony starts. Where one person's name isn't on the deeds, there is protection afforded to that person. Where that property is their main matrimonial home, they have rights of occupation afforded to them by the Family Law Act, and on that basis an application can be made to the Land Registry to protect those rights immediately as an emergency. Where there are joint savings and joint incomes going into an account, you need to consider whether to open a separate account on either side and pay those incomes into those separate accounts, and then put in a lump into the joint account to meet the overall outgoings for the property. Where one person decides not to pay their income into the joint account or from their sole account into the joint account to meet those reasonable needs for the property, specialist advice needs to be taken as to what those reasonable needs actually are, because one person's belief as to what's reasonable is not exactly what the court might define as reasonable. And then emergency correspondence needs to be written to the other party to attempt to force them to pay those monies in, and if not, unfortunately, an application to the court will be necessary. This is an area that can become quite complex, and specialist legal advice should be taken right from the outset to get your case off on the right footing. Many clients want to know how long the process is going to take and whether that can be foreshortened. If agreement is reached right from the outset and the paperwork can be drawn up swiftly, the process can take as little as 5 months and the cost can be kept to a minimum. We at Martin Tolhurst keep the client updated in respect of costs regularly so that we don't go over any agreed bandings with them. Often cases are not as simple as we would like, and on occasion there needs to be an application made to the court or lengthy financial disclosure to be given. Clients can be reassured that this will not take as long as they actually think it's going to take, and that costs will not spiral out of control. You get within a court time frame, and on that basis clients have light at the end of the tunnel as to when this matter is actually going to be resolved. In relation to division of assets generally, there needs to be a process of full financial disclosure. If agreement is reached at the outset, this can be in a shortened form, but if there remain issues as to children or financial matters, inherited assets, there needs to be a rather longer form drawn together. This can take some time. I get a lot of questions in relation to inherited property and monies won on the lottery, say, as to whether that needs to be disclosed. Firstly, certainly everything needs to be disclosed from the outset. There is no way that any asset can be kept separate and apart from financial disclosure. And secondly, if it's monies that one person has brought into the relationship, in certain circumstances and certainly in short marriages, those assets can be treated differently from the other, say, more matrimonial assets of the matrimonial home, or any further vehicles and the like. Still on the subject of finances, pensions certainly need to be considered. They are an asset treated differently to property or savings, but they still need to be taken into account. You would usually look in long marriages at there being a pension share being passed from the person that has the pension to the person without, or with that smaller pension provision. There certainly needs to be a valuation of those pensions done right from the outset. That can take up to 3 months to be produced, therefore that needs to be a consideration right from the outset to be put together. And then pensions can be looked to be compared on a like-for-like basis, so that we can decide as to whether there should be a pension share on one end, or whether there should be a capital buyout of that pension claim on the other end. A number of clients I have asked about their spouse being given advice on legal aid, or public funding as it's now known. The spouse has to be aware that there is a statutory charge that applies, that if you preserve or recover any monies at the end of the matter, or any property at the end of the matter, those fees have to be paid back, and it comes as quite a surprise to people when they come to hear that. Where there are children involved, maintenance can be dealt with voluntarily between the parties, or if a maintenance assessment is needed, you can take the matter to the Child Support Agency. Either party can apply for a maintenance assessment to be carried out, and they use set formulae as to how that is calculated. If the non-resident parent then has care for any part of the week, or on average throughout the year, then there can be deductions made as to the calculation. Maintenance is only paid when one person leaves the matrimonial home or the parties are apart. Usually where the parties are married, they both have a say in major decisions in the child's life. This is usually known as parental responsibility, and on that basis there isn't, unfortunately, any say in day-to-day care, and the non-resident parent needs to be aware, therefore, that contact isn't on a set pattern for every single child. It is case specific, and they should certainly take legal advice as to what might be right for them, worked around employment requirements and any other family members that have contact with that child. Once a decree absolute is issued, a lot of people believe that's the end of the matter. Unless financial matters have been resolved within the process, they still remain live even after decree absolute has been pronounced, until there has been an order of the court made.